here. I don't usually have a lot of people who watch my videos, but I just kind of thought, you know, it would be kind of cool to go ahead and read the Colorado Supreme Court ruling that tossed Donald Trump off the ballot in that state. And it would be interesting to kind of see how people responded to it. So pretty much, I was originally recording it to do a video of it, and I just thought, you know what? Why don't I just go ahead and just kind of just kick this off? So pretty much, it's called this. The case is called Anderson versus Griswold, and it is about election law, 14th Amendment, First Amendment, political questions, hearsay is what it's the little thing there. And it's pretty much there was a district court, and then the Supreme Court of Colorado decided, okay, they needed to take the case, and pretty much it is, was Donald Trump disqualified from holding office, being on the ballot after the events of 3 years ago? Me personally, I say yes. Yes, because of the fact that he engaged in insurrection, and someone who is an assault on the political process, an assault on an election is especially of that magnitude, insurrection. And they should not be able to hold office, period, dot, end of story. So the Supreme Court of the state of Colorado, they list all the interveners and all the intervenees. I would like to take a look at some of the amicus briefs, um, just to kind of see what they were talking about here. And then I'm going to move down to the per curiam. The per curiam, so more than 3 months ago, a group of Colorado electors eligible to vote in the Republican presidential primary, both registered Republicans and unaffiliated voters, they're called the electors here, filed a lengthy petition in the district court for the city and county of Denver, which will be referred to as the district court, asking that the court rule the former president Donald Trump may not appear on the Colorado Republican presidential primary ballot, invoking provisions of Colorado Uniform Election Code, all these numbers, the election code. The electors requested that the district court prohibit Jena Griswold in her official capacity as Colorado Secretary of State or the Secretary from placing Trump's name on the presidential primary ballot. They claimed that Section 3 of the 14th Amendment of the U.S. Constitution, referred to as Section 3, disqualified Trump from seeking the presidency. More specifically, they asserted that he was ineligible under Section 3 because he engaged in insurrection on January 6, 2021, after swearing an oath as president to support the U.S. Constitution. So they allowed the Colorado State Republican Committee to come and to intervene, and there was a 5-day district trial. Court found very clear evidence that Trump engaged in insurrection as those terms under Section 3. Anderson versus Griswold District Court. But the district court concluded Section 3 does not apply to Trump. Therefore, the court denied the petition to keep Trump off the presidential primary ballot. ID at Part 6 conclusion. The electors and Trump have sought this court's review of various rulings of the district court. We affirm in part and reverse in part. We hold as follows: the election code. Okay. The election code allows the electors to challenge Trump's status as a qualified candidate based on Section 3. Indeed, the election code provides the electors their only viable means of litigating whether Trump is disqualified from holding office under Section 3. Congress did not need to pass implementing legislation for Section 3's disqualification provision to attach, as Section 3 is in fact self-executing. So it executes all by itself. It doesn't need any companion legislation. Judicial review of Trump's eligibility for office under Section 3 is not precluded by the political question doctrine. Section 3 encompasses the office of the presidency and someone who has taken an oath as president. On this point, the district court committed a reversible error. I don't think so. Okay. So they said that it didn't. Okay, so the district court said no, it doesn't, but they said that they do. And They are they are an officer of the government, so therefore they should be okay. Now I see. The district court did not abuse its discretion in admitting portions of Congress's January 6th report into evidence at trial. The district court did not err in concluding that the events at the U.S. Capitol on January 6, 2021 constituted an insurrection, and the district court did not err in concluding that Trump engaged in that insurrection through his personal actions. Trump's speech inciting the crowd that breached the U.S. Capitol on January 6, 2021 was not protected by the First Amendment. The sum of these parts is this: that Trump is disqualified from holding office of the president under Section 3 because he's disqualified. It would be a wrongful act under the election code for the secretary to list him as a candidate on the presidential primary ballot. We do not reach these conclusions lightly. We are mindful of the magnitude and weight of the questions now before us. We are likewise mindful of our solemn duty to apply the law without fear or favor, and without being swayed by public reaction to the decisions that the law mandates we reach. We're also cognizant that we travel in uncharted territory, and that this case presents several issues of first impression. But for our resolution of the electors' challenge under the election code, the secretary would be required to include Trump's name on the 2024 presidential primary ballot. Therefore, to maintain the status quo pending any review by the U.S. Supreme Court, we stay our ruling until January 4, 2024, the day before the Secretary's deadline to certify the content of the presidential primary ballot. If review is sought in the Supreme Court before the stay expires on January 4, 2024, then the stay shall remain in place, and the Secretary will continue to be required to include Trump's name on the 2024 presidential primary ballot until the receipt of any order or mandate from the Supreme Court. So here we get into the background. On November 8th, 2016, Trump was elected as the 45th president of the United States. He served in that role for 4 years. On November 7th, 2020, Joseph R. Biden was elected as the 46th president of the United States. Trump refused to accept these results, but President Biden now occupies the office of president. On December 14th, 2020, the Electoral College officially confirmed the results: 306 electoral votes for President Biden and 232 for then President Trump. Trump then continued to challenge the outcome both in courts and in media. On January 6, 2021, pursuant to the 12th Amendment, U.S. Constitutional Amendment 12, and the Electoral Count Act, 3 U.S. Code Section 15, Congress convened a joint session to certify the Electoral College votes. Trump held a rally that morning at the Ellipse in Washington, D.C., in which he, along with several others, spoke to the attendees. In his speech, which began around noon, Trump persisted in rejecting the election results, telling his supporters that we won in a landslide and we will never concede. He urged the supporters to confront the egregious assault on our democracy, walk down to the Capitol, show strength, and that if they did not fight like hell, not have a country anymore. Before his speech, portions of the crowd began moving toward the Capitol. Before his speech ended, portions of the crowd began moving toward the Capitol. Below, we discuss additional facts regarding the events of January 6th as relevant to the legal issues before us. Just before 4 a.m. the next morning, January 7th, 2021, then Vice President Michael R. Pence certified the electoral results, officially confirming President Biden as President-elect of the United States. Trump now seeks the Colorado Republican Party's 2024 presidential nomination. Now we move into procedural history, where they tell us who initiated, under what claims, and what happened here. On September 6, 2023, the electors initiated the proceedings against the secretary in Denver District Court under Sections 14124, Section 4, 11113, Section 1, 1351, 105, CRS 2023, and CRCP 57A. In their verified petition, the electors challenged the secretary's authority to list Trump as a candidate on the 2024 Republican presidential primary election ballot and any future election ballot based on his disqualification from public office under Section 3. Trump intervened and almost immediately filed a notice of removal to federal court asserting federal question jurisdiction. In light of the removal, the Denver District Court closed the case on September 8th. On September 12th, the federal district court remanded the case back to state court, so they just sent it back, concluding that it lacked jurisdiction because the electors had no Article 3 standing and the secretary had neither joined nor consented to the removal. Once the electors filed proof with the Denver District Court and that all parties had been served, the court reopened the case on September 14th. At a status conference 4 days later, At a status conference 4 days later on September 18th, the secretary emphasized that she must certify candidates for the 2024 presidential primary ballot by January 5th. The court set the matter for a 5-day trial beginning on October 30th. On September 20th, with the parties' input, the court issued expedited case management deadlines for a host of matters, including the disclosure of expert witnesses, witness lists, and exhibits, as well as for briefing and argument on several motions. The court granted the Colorado Republicans' motion to intervene on October 5th. On October 11th, the Secretary's office received Trump's signed and notarized statement of intent to run as a candidate for a major political party in the presidential primary. The approval for him to do so, signed by the Colorado Republican Party, asserting Trump was a bona fide and affiliated with the Republican Party, and the requisite filing fee. On October 20th, the district court issued an omnibus order addressing many outstanding motions. Regarding Trump's notions, the court reached 3 conclusions that are relevant now. The electors' petition involved constitutional question, but remained a challenge against an elected official based on her alleged duties under the election code, and such a claim was proper under 11113 as a matter of procedure, sections 1204 that expressly incorporates 11113, and that the section 11113 does not limit challenges to acts that have already occurred, but provides relief when the secretary is about to take an improper or wrongful act. Thus, because the electors had alleged such an act, the matter was ripe for decision. And 3, it could not conclude as a matter of law that the 14th Amendment excludes a candidate from the presidential primary ballot, or that the secretary has the authority to determine candidate qualifications, so those issues would be determined at the trial. Regarding the Colorado Republicans' motions, the court in relevant part concluded that the state does not violate a political party's First Amendment associational rights by excluding constitutionally ineligible candidates from the presidential primary ballot, but also rejected the Colorado Republicans' argument that it extended to purport to raise an independent constitutional claim beyond the proper scope of a Section 11113 proceeding. On October 23rd, Trump filed a petition for review in this court asking us to exercise original jurisdiction to halt the scheduled trial. 4 days later, we denied the petition without passing judgment on the merits of any of Trump's contentions. On October 25th, the district court denied Trump's 14th Amendment-based motion to dismiss. As relevant now, the court concluded that, 1, it would not dismiss the case under the political questions doctrine, but it reserved the right to revisit the doctrine to the extent that there is any evidence or argument at trial that provides the court with additional guidance on whether the issue of a presidential eligibility has been delegated to the United States Congress. Okay, so I've been reading for a little while, and I'm just going to say here, I guess that this is saying that there is no extent that there is evidence or argument at trial that provides the court with additional guidance on whether the issue of presidential eligibility has been... Okay, so pretty much they're trying to punt it to Congress, and he tried to punt it to federal court. They said no. They remanded it back. He tried to get it to federal court again, I think. Or no. He tried to get it to the Supreme Court of Colorado originally, and they said, nope, we're not going to do that. Okay, on whether the issue of presidential eligibility has been delegated to the U.S. Congress. Okay. Whether Section 3 is self-executing is irrelevant because Section 141204 allows the Secretary to exclude constitutionally disqualified candidates, and states can and have applied Section 3 pursuant to state statutes without federal enforcement legislation. Interesting. I didn't know that. And then it would reserve for trial the issues of whether Section 3 applies to a president and whether Trump had engaged in insurrection. The trial began as scheduled on October 30th. The evidentiary portion lasted 5 days, with closing arguments almost 2 weeks later on November 15th. During those 2 weeks, the electors, the Secretary, Trump, and the Colorado Republican Party submitted proposed findings of fact and conclusions of law. The court issued its written final order on November 17th, finding by clear and convincing evidence that the events of January 6th constituted an insurrection and Trump engaged in that insurrection. The court concluded further, however, that Section 3 does not apply to a president because, as the terms are used in Section 3, the presidency is not an office under the United States, nor is the president an officer of the United States who has previously taken an oath to support the Constitution of the United States. I kind of find that interesting because of the fact that they swear an oath to uphold the Constitution, and he is an officer, so I don't understand how that doesn't apply to a president because they take an oath to support the Constitution of the United States, not themselves. Okay. So, accordingly, the Secretary could not exclude Trump's name from the presidential primary ballot, and Anderson Part 6 conclusion, which we'll get to. On November 20th, the electors and Trump sought this court's review of the district court filings under 11113. We accepted jurisdiction of the parties' cross petitions, following extensive briefing from the parties and over a dozen amici, which is amicus briefs, which are friend of the court, and they will. So what usually happens in these cases is there's amicus briefs, and amicus amici is friend of the court benefit or friend of the court briefing. So pretty much before, in the Supreme Court, where I've seen this a lot, but in most court filings, they will have an amicus brief, in which they pretty much state how they would kind of argue the case. It's a way of saying, hey, this is why, I'm filing amici for the plaintiffs, and this is why I think they're right to bring this case, and this is how, based on the legal conclusions that we are going to draw, this is why I think that you should rule in favor of the plaintiffs, and the defendants also have amicus briefs as well on their side. So, okay, what did I say here? Okay. We held oral arguments on December 6th and now issue this ruling. Number 3, analysis. So this is where we get into the teeth of the opinion right here. It only took me 18 minutes to get there. We begin with an overview of Section 3. We then address threshold questions regarding 1, whether the election code provides a basis for review of the elector's claim, 2, whether Section 3 requires implementing legislation before a disqualification provision attaches, and 3, whether Section 3 poses a non-justiciable political question. After concluding that these threshold issues do not prevent us from reaching the merits, we consider whether Section 3 applies to a president. Concluding that it does, we address the admissibility of Congress's January 6th report. The report, before reviewing and ultimately upholding the district court's findings of fact and conclusion of law in support of its determination that Trump engaged in insurrection. Lastly, we consider and reject Trump's argument that his speech on January 6th was protected by the First Amendment. Personally, I also reject it too because of the fact that he knew that his cronies, his cult followers, his cult people were going to storm the Capitol, because he also refused calls from D.C. Mayor Muriel Bowser for added protection, and he also refused to keep Capitol police beefed up. But you saw how he called the National Guard and all that in for when BLM was there, and he wanted them to go crack some skulls. So his speech on January 6th was not free speech. I feel it was incitement, and therefore it should not have free speech protections. Section 3 of the 14th Amendment and Principles of Constitutional Interpretation. This is Section A, 3A. The end of the Civil War brought what one author termed a second founding of the United States of America. Eric Forner, The Second Founding, How the Civil War and Reconstruction Remade the Constitution, 2019. Reconstruction ushered in the 14th Amendment, which includes Section 3, a provision addressing what to do with those individuals who held positions of political power before the war, fought on the side of the Confederacy, and then sought to return those to those positions. National Archives, 14th Amendment of the U.S. Constitution, Civil Rights, 1868. Explaining that the 14th Amendment was passed by Congress on June 13th, 1866, and officially ratified on July 9th, 1868. See also Gerard Magliocca, Amnesty, and Section 3 of the 14th Amendment. Section 3 provides, no person shall be a senator or representative in Congress or elector of president and vice president or hold any office, civil or military, under the United States or under any states who, having previously taken an oath, as a member of Congress or an officer of the United States, or a member of any state legislature, or as an executive or judicial officer or of any state, to support the Constitution of the United States, shall have engaged in insurrection or rebellion against the same, or given aid or comfort to the enemies thereof. But Congress may, by a 2/3 majority of each house, remove such a disability. 14th Amendment, Section 3. In interpreting a constitutional provision, our goal is to prevent the evasion of the provision's legitimate operation and effectuate the drafter's intent. People v. Smith. To do so, we begin with Section 3's plain language, given its terms and their ordinary and popular meanings. To discern such meanings, we may consult dictionary definitions. If the language is clear and unambiguous, then we must enforce it as written, and we do not need to turn for other tools of construction. However, if a provision's language is reasonably susceptible to multiple interpretations, then it is ambiguous, and that we may consider the textual, structural, and historical evidence put forth by the parties. Zivotofsky, ex rel. Zivotofsky versus Clinton, 2012. And we will construe the provision in light of the objectives sought to be achieved and the mischief to be avoided. These principles of constitutional interpretation apply to all sections of this opinion in which we address the meaning of any constitutional provision. Section B. The state court has the authority to adjudicate a challenge to presidential candidate qualifications under the election code. The elector's claim is grounded in sections 1-4-1204 and 1-1-113 of the Election Code. They argue that it would be a breach of duty or a wrongful act under the Election Code for the Secretary of State to place Trump on the presidential primary ballot because he is not a qualified candidate based on Section 3's disqualifications. The electors therefore seek an order pursuant to sections 1-1-113 directing the Secretary to not place Trump on the presidential primary ballot for the election to be held on March 5th, 2024, or any future ballot. Trump and the Colorado Republicans contend that the Colorado courts lack jurisdiction over the elector's claims, and that the electors cannot state a proper Section 1-1-113 claim, in part because the elector's claim is a constitutional claim that cannot be raised in the Section 113 action, 1-1-113 action, under this court's decision in Frazier v. Williams and Kuhn v. Williams per curiam. The Colorado Republicans also argues that Secretary lacks authority to intervene with a political party's decision-making process or to interfere with that party's First Amendment right of association to select its own candidates. Lastly, Trump argues that the expedited process under 1-1-113 are insufficient to evaluate the elector's claim. Okay, so pretty much this is what the dissent was focusing on, that they lack jurisdiction was another part. It didn't really make any sense because, anyway. Before considering each of the arguments in turn, we must explain the standard of review for statutory interpretation and then provide an overview of the election code provisions at issue. Turning to interveners' contentions, we first conclude that the district court had jurisdiction to adjudicate the elector's claim under 11113, but recognizing the ability to exercise jurisdiction here does not mean the electors can state a proper claim under sections 11113. We explore whether states have the constitutional power to assess presidential qualifications. Okay. We conclude that they do, provided their legislatures have established such authority by statute. Analyzing the relevant provisions of the election code, we then conclude the General Assembly had given Colorado courts the authority to assess presidential qualifications, and therefore that the electors have stated a proper claim under sections 1.4.1204 and 1.1.113. We next address interveners' related argument and conclude that limiting the presidential primary ballot to constitutionally qualified candidates does not interfere with the Colorado Republicans' associational rights under the First Amendment. Finally, we conclude that Section 11113 provides sufficient due process for evaluating whether a candidate satisfies the constitutional qualifications for the office they seek. Now, also, I just want to say here, I remember seeing, what was it, in the dissent, what was it they were talking about? They didn't talk about any associational rights in the dissents, which honestly kind of brings up a red flag to me. And interesting. Okay, standard of review, paragraph 33. I wonder how many more pages we got here. Wow, okay, let's go back here. Woo! Paragraph 39, I believe I was at. Okay. Oh, no, okay. Oh, for the, okay, I see. Wait, District Right had the, okay, hold on. I think I'm at it. I think I've, where it is, okay, standard of review, 33. We review the district court's interpretation of the relevant statutes de novo, Griswold versus Ferrigno-Warren. In doing so, our primary objective is to effectuate the intent of the General Assembly by looking to the plain meaning of the language used, considering within the context of the statute as a whole. When a term is undefined, we must construe a statutory term in accordance with its ordinary or natural meaning. Quoting Coven versus People 2018. If the language is clear, we apply it as written, Ferrigno-Warren. If, however, the language is reasonably susceptible to multiple interpretations, we may turn to other tools of construction to guide our interpretation. Cohen. Then, these may include consideration of the purpose of the statute and the circumstances under which the statute was enacted, the legislative history, and the consequences of a particular construction. We also avoid constructions that would yield illogical or absurd results. Number 2, the presidential primaries under the election code. Before addressing the merits, we provide a brief overview of the election code's provisions relating to the presidential primary elections. Article 7, Section 11 of the Colorado Constitution demands the General Assembly to pass laws that secure the purity of elections and guard against abuses of the elective franchise. Pursuant to this constitutional mandate, the Secretary's duties under election code include supervising the conduct of primary and general elections in the state and enforcing the provisions of election code. Part 12 of Article 4 of the Elections Code governs presidential primary elections, explains that it is the intent of the people of the state of Colorado that the provisions of this Part 12 conform to the requirements of federal law and national political party rules governing presidential primary elections. The reference indicates that the legislature has envisioned Part 12 as operating in harmony with federal law, including requirements governing presidential primary elections. As such, it is intrusive when interpreting other provisions of Part 12. The election code limits participation in the presidential primary to qualified candidates. Each political party that has a qualified candidate is entitled to participate in the Colorado presidential primary election, emphasis added. Allowing a write-in candidate to participate in the presidential primary election if he or she submits an affidavit stating that he or she is qualified to assume the duties of office if elected. As a practical matter, the mechanism through which a presidential primary hopeful attests that he or she is a qualified candidate is the statement of intent or affidavit of intent filed with the secretary, requiring candidates to submit to the secretary a notarized statement of intent, requiring a write-in candidate to file a notarized statement of intent in order for votes to be counted for that candidate, and stating that such affidavit must be accompanied by the requisite filing fee. The secretary's statement of intent form for any major party presidential primary candidate requires the candidate to affirm via check boxes that he or she meets the qualifications set forth in Article 2 of the U.S. Constitution for the office of president. Specifically, the candidate is at least 35 years old, has been a resident of the United States for at least 14 years, and is a natural-born U.S. citizen. The form further requires the candidate to sign an affirmation that states, "I intend to run for the office stated above and solemnly affirm that I meet all the qualifications for the office as prescribed by law." No party has challenged the Secretary's authority to require candidates to provide this information on the Statement of Intent form. Section 1412041 requires the Secretary to certify the names and party affiliations of the candidates to be placed on any primary presidential primary election ballots no later than 60 days before the presidential primary election. For the 2024 cycle, that deadline is January 5th, 2024. So Section 1412041 states, the only candidates whose names shall be placed on the ballots for the election shall be candidates who, B, are seeking the nomination for the president of a political party as a bona fide candidate for president of the United States pursuant to the political party rules and are affiliated with a major political party that received at least 20 votes cast by eligible electors in Colorado at the last presidential election, and C, have submitted to the Secretary no later than 85 days before the date of the presidential primary election a notarized candidate statement of intent together with either a non-refundable filing fee of $500 or a petition signed by at least 5,000 eligible electors. For the 2024 election cycle, that deadline to submit these was December 11th, 2023. Section 1412044 allows challengers to the listing of any candidate on the presidential primary ballot. Any such challenges must be brought no later than 5 days after the filing deadline for candidates, but must provide notice of an alleged impropriety that gives rise to the complaint. The district court must hold a hearing no later than 5 days after the challenge is filed to assess all validity of alleged improprieties. The statute does not limit the length or content of the hearing. It does, however, require the district court to issue findings of fact and conclusions of law no later than 48 hours after the hearing concludes. The parties filing the challenge has the burden to sustain the challenge by a preponderance of the evidence. Challenges under 1412004 must be brought through the special statutory procedure found in Section 11113 for adjudicating controversies that arise under the Election Code. Section 1412044, providing that any challenge to the listing of a candidate on the primary ballot must be made in writing and filed with the district court in accordance with Section 11113.1, and any order entered by the district court may be reviewed by the Supreme Court in accordance with the section. Section 11113 has deep roots in Colorado election law. It originated as an 1894 amendment to Colorado's Australian ballot law, first adopted by the 8th General Assembly in 1891. Much like its present-day counterpart, the original provision established procedures for adjudicating controversies between election officials and any candidate, political party, officers or representatives, or person making nominations. The current version of 11113 establishes, with exceptions not relevant here, the exclusive method for the adjudication the exclusive method for the adjudication of controversies arising from a breach or neglect of duty or other wrongful act that occurs prior to the day of the election. It provides, when any controversy rises between an official charged with any duty or function under this code and any candidate or any officers or representatives of a political party or any persons who have made nominations, or when an eligible elector files a verified petition in a district court competent jurisdiction that a person charged with a duty under this code has committed or is about to commit a breach or neglect of duty or other wrongful act, after notice to the official, which includes an opportunity to be heard, upon finding of good cause, the district court shall issue an order requiring substantial compliance with the provisions of this code. The order shall require the person charged to forthwith perform the duty or to desist from the wrongful act, or to forthwith show cause why the order should not be obeyed. The burden of proof is on the petitioner. Section 11113 proceedings are also provided for expedited, albeit discretionary, appellate review in this court. Either party must seek review from this court within 3 days after the district courting proceedings conclude. If the court declines jurisdiction of this case, the district court decision is final and is not subject to further appellate review, at least in the state. Although Colorado's expedited statutory procedure for litigating election disputes may be unfamiliar nationally, our courts, particularly in Denver District Court, the proper venue when the secretary is the named respondent, are accustomed to Section 11113 litigation. Such cases arise during virtually every election cycle, and this court has exercised jurisdiction many times to review those disputes. Moreover, it is not uncommon for Section 11113 cases to require courts to take evidence and grapple with complex legal issues. Farina Warren, describing a district court hearing held 1 month after the petitioner filed her verified petition and after the parties filed briefing, and to determine whether substantial compliance was the appropriate standard for the minimum signature requirement. How to apply that standard, and whether, based on 4-factor test, a prospective U.S. Senate candidate satisfied that standard. Kuhn, describing a district court hearing to assess evidence and testimony concerning the residency of 7 circulators of a petition to re-elect a congressional representative. Mayer versus Lamb, requiring an evidentiary hearing in the district court that involved, among other things, the content of the ballots cast for a write-in candidate. Even early cases recognized the original 1894 provision contemplated the taking of evidence where the issues required it. Leighton versus Bates, 1897. Okay, so this is where I'm gonna head off at this one. I am going to highlight this thing, and then soon, and then come back later, and we will continue. So this will be part 1 here. I'm going to, I don't know, the reason that I'm reading this is because I guess I just wanted to do it on the 6th, but hey, I'm just gonna continue doing it. I will see you tomorrow with the district court has jurisdiction to adjudicate the elector's claim under the election code. All right, talk to you soon, and thank you so much for tuning in.